manage, bread don't come down, rice don't go up. How it be we still dey Nigeria? Last, everybody go shop their own breakfast. Una do well, oh. We thank you so much. Say una dey there. They wait for this ogbonge program wey they call Area Matter. We don't come as usual, and we don't carry our gbogbo tigbo come so that we go follow discuss together. My name na Temitope Oyefolu. As una know, I dey come.
My name na Tobechukwu Kasme. To handsome woke marama okwi man. I no get long story today.
Okay, una know say as we don talk say today na today. The court case wey una dey hear with our presido and Atiku and Labour Party wey be Obi. You know say the case don dey go on. If you dey watch your TV, you go see am from Abuja. And the thing wey dem just judge now be say court to talk say the court to lack jurisdiction to hear Atiku's case. That one don finish.
You know say if this English now they talk now, English not be our mate.
You know say if you lack jurisdiction, now be say you no get the constitutional right to
look into that Atiku's case.
In fact, we go join the case as they waka. So that you na go hear am well as
no be even so that they go hear, so that they go to wash from the horse's mouth. Man, you know say Nigeria now they go talk say Mr. Oyefolu am to handsome.
You talk something.
They talk. Una go hear when 7 men justices.
no be justice, just justices.
When one justice is linked to raise to power 6, power 7, you will have 7 men justices having saying and doing anything.
Una wey una never go join na television where they drive Marwa Park.
Join VOP.
Join VOP
on YouTube.
On YouTube, they watch am live as e dey see the where small time e no go take. But the one wey they don't judge to come out. Be say the court talk say they lack the jurisdiction. The constitutional emolument
to hear Atiku's case
an ingredient. So in other words, we no fit answer una issue. No na carry am go another place. Now be the koko for Atiku. Oh yeah, may we join.
Follow us as we want link up. We don't link up. Okay, now some people come there talk say wetin dey happen. We wan join una, but before we join una, we know say some people don dey pray, some people don dey cool, some people don dey quiet, because as we dey watch here live now, before we link una go see some lawyers wey be say they dey quiet like person wey dey classroom wey teacher dey floor.
You don see rat wey chop indomie seed before? You don't see them.
I never see
you see, you know where they plant India hemp? If you go the bush where they plant India hemp and fire can't catch the bush.
They quiet.
No, you know, say this thing go as the thing they burn, it go come be like say all the animal where they the bush, they don't smoke Igbo. They smoke Igbo. You know there's the smoke where they come from the Igbo. All the animal where they the bush, they go come inhale the smoke. You go come see say you dey smoke Igbo.
And you know say for what you dey see now, some lawyers don't keep their head right. They're independent. They can't keep them left. But for now, me una watch.
I bet me will join them.
Transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IReV portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IReV portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC citation supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and results announced. In his argument, Chief Olanikpekun said, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IReV in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IReV. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IReV, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABS CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62, 1 and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections results. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by Section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of results or even electronic transmission of results, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Leonard Soul submitted finally that the Electoral Act 2022, the INEC regulations and manual points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulations, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanikpekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peterside, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Soul, any argument for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance, covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 of 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act, that these new provisions deal with the new manner of transmission of results as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, Sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real time to the IReV portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IReV portal? The court below held that the IReV portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IReV portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collected at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IReV portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IReV deprives the public and even election administration legislators and monitors the opportunity of viewing the portal and comparing the result collected with the ones transmitted into the IReV. Truth must be told, the non-functioning of the IReV may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IReV is not a collation system, and I agree. I refer to paragraph 93 of the first respondents guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IReV portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1. The Nigeria Police Force, and 2. Agents of political parties. End of quote. Paragraph 93 of the first respondents guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IReV portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation there is a result either from the hard copy with INEC or the electronically transmitted copy or the IReV portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IReV portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My lords, having failed to means we or that there was any miscarriage of justice since of this started. Section 137 Electoral Act relied upon by the appellants for the failure of non-compliance in the manner we are used to provide. I quote, it shall not be necessary for a party who alleges non-compliance with the conduct of election to President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in section 134 2b of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages, a candidate scores the highest number of votes in a presidential election and has 25% or one quarter of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT. Are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of one quarter of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of one quarter of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedural Rules 2019 is not applicable in election matters. Learned senior counsel for the appellants for the decision of the court below for relying on paragraph 4.5 of the first schedule to the Electoral Act 2022 and for failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedural Rules. He submitted that the interpretation given to paragraph 4.5b of the first schedule to the Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 4.5b of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled by new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings, and where the Electoral Act requires recourse to civil procedural rules, it must be made subject to the provisions of the Act. My noble lords, a combined reading of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 4.5 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bit, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in OK and Mimiku citation supplied. In his contributory judgment in the above case, Clara Ogumbi J.S. retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt to amend the petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134.1 of the Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citations applied. This court held and to file additional witnesses statements after the prescribed period for presenting election testify. But as was argued by the learned senior counsel for the first respondent, circumvent the provisions of the law and the effect and purpose of section 285 sub 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' collation agents at the court below. The appellants are aggrieved by the verdict of the court that the evidence of these witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of, and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the collation agents in this instant case, who are PW1, 2, 5, and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Ojumobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state collation agents and national collation agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW 1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary